Reddy ji, would you like to say something as the mover of the resolution?
Sir, actually, all honorable members have spoke. One important point I want to draw the attention of Honorable Finance Minister, which is very important in the interest of the Indian economy, interest of the banks and the financial system. That is, actually, as per the NCLT, there are two ways. One is what do you call it? Operational creditors, finance creditors. To protect the finance creditors and operational creditors, this bill has come now. So finance creditors means banks. So no problem, banks will be looked after. Regarding the operational creditors, that means if any industry, if it is having any creditors, 1 lakh, 5 lakhs, 10 lakhs also, any one creditor also can move the NCLT the board. They can get a resolution. Of course, they have to give 15 days notice. By chance, in 15 days notice, if they don't give proper reply from any industry or any company, they have a right to go to NCLT and get the resolution. Once the resolution is passed, they will appoint one interim insolvent expert to monitor completely the total management. They have been given sweeping powers. So who is the interim man, interim observer? He is nothing but a chartered accountant. If a chartered accountant, he is actually appointed by the NCLT board, and on behalf of a small creditor of, let us say, a company which is doing 10,000 crores. For 10,000 crores company, if 5 lakhs, 10 lakhs creditor, if he moves and gets the power and then now gets appointed with the interim observer, then interim observer will be chartered accountant with sweeping powers. He will dissolve the board. First to dissolve the board. Once you dissolve the board, he will have full control of the management. So I would like to know what he knows about the company. Then what will happen to the company management? Then if company doesn't not properly manage, then how the banks will get their back money? So banks will suffer. So this is the biggest actually loophole this bill, sir. So this bill, finance minister should apply in mind. Go to examine thoroughly. This, suppose 10,000 crores, there should be some limit. Simply 1 lakh creditor or 10 lakhs creditor cannot go and smash the company completely. So there should be some system that mere credit, this is actually meant for the financial operators, that means banks. So this normal, other operators, these operational creditors are only creditors who supplies the materials, who does the sub-construction, who will be having 5 lakhs, 10 lakhs, 20 lakhs or 50 lakhs business with a big industry, 1,000 people may be there. So one man cannot finish the company. With the present law, sweeping powers are given by the law board. NCLT can give it simply. I have seen examples in Hyderabad, Bombay and Delhi where big companies were simply shaken. Of course, they could be saved again in the appeal. Otherwise, if the appeals, if they are not successful or it is not done, the company will be smashed. If the company is smashed, all the banks will be finished. Banks' money will get stuck. I don't want to take much time. Therefore, in my clarification now, what I want is, I want to reply from Honorable Finance Minister that how could you give a sweeping powers to a creditor who will give a notice for 15 days. If he doesn't give by chance a reply from the company, he has power to go to NCLT board and get appointed the interim observer, then with full sweeping powers and remove the board and take the management. Well, I want this clarification while actually moving the bills.
Thank you very much, Subbarami Reddy ji. Now, Honorable Finance.